Good morning, everyone. Thank you for signing up and joining us on this morning for a copyright webinar that's put on by some of the members of the CAUL Copyright Group and a couple additional members, Corinne and Denise from the Mount. I have an outline kind of in front, and so we just kind of did a bit of a technology check. So if you're having any tech issues or can you hear me, just let us know. Put like a little smiley face in the chat box. I always take a no news is good news.
And if you can't, okay, yeah, you won't hear it.
So I have a slide in front of you, which kind of is there an outline for the morning for the session. And so we're just doing the technology check now, and then we're going to go do an upgrade on copyright in Canada with Simon. Followed by scenario 1 with Corinne and Denise, scenario 2 with Josh, and scenario 3 with Simon. So I don't know if I introduced myself or not. I'm Amy, and I'm the Metadata and Copyright Librarian at St. Mary's University. And FYI, the session is being recorded, so if you miss chunks, you can always come back to it. I'll also be typing in the chat a little bit, just because if anyone has any tech issues or any other accessibility issues, I can kind of type some of the stuff that's being talked about that might not be evident on the screen. As well as I do have a handout for each of the scenarios, and so I'm going to attach the first one now, which is Simon and the backgrounder, and I'll hand it over to Simon.
Thank you very much. It's Simon Lloyd here from the University of Prince Edward Island. I'm just going to, you'll be seeing on screen in a minute, hopefully, just a short outline that the committee has worked up, just trying to flag a few issues that we think will particularly bear watching through 2018. And as I'm sure everybody here appreciates, copyright can be predictably unpredictable, so there's always the potential for surprises, welcome or otherwise. But there were 3 particular things we wanted to flag at the moment. So firstly, of course, is the Copyright Modernization Act review. When this act came into force in 2012, there was a mandatory 5-year parliamentary review period. This review was officially announced, finally, in December 2017. The lead ministers on the review are the Honourable Navdeep Bains, who's the Minister of Innovation, Science and Economic Development, and the Honourable Melanie Joly, who's Minister of Canadian Heritage. Details of the review, including any hearings, consultations, have not yet been announced so far as I'm aware. I did have another look online again just this morning, but I don't see any details yet. If anybody does have any information on that, please feel free to share. It is known that the federal government was lobbied heavily by the publishing industry and allied stakeholders in advance of the review, with a reported emphasis on repealing education as a fair dealing purpose. The second issue that we wanted to highlight for folks are the currently ongoing consultations regarding the Copyright Board. Now, as some of you may be aware, in December 2016, the Senate Standing Committee on Banking, Trade and Commerce in November they held hearings for several days and heard from quite a range of stakeholders in those hearings. After that, in December of 2016, they issued a report decrying, quote, the glacial pace of copyright proceedings in Canada, close quote, and calling urgently for, quoting again, thorough, in-depth examination of the Copyright Board of Canada's mandate, practices, and resources, close quote. The Senate committee anticipated that this examination would be undertaken in the course of the forthcoming Copyright Act review, but the government instead launched expedited consultations on the Copyright Board in August of 2017. This consultation invited written submissions, which are available, and I've included a link to that in the backgrounder sheet that will be shared with you. Now, disappointingly, several stakeholders who made submissions, including Access Copyright, the Writers' Union of Canada, and the Association of Canadian Publishers, made submissions calling for mandatory and retroactive tariffs to be applied to copying tariffs to be applied to Canadian educational institutions. And again, as I say, I've included the link to all those submissions which have been made available online. There was also a very interesting discussion paper that was released by the government at the same time that they launched the Copyright Board consultations. That's available online as well, and I've included the link in the background paper that's being shared. The final issue that I'm sure folks will recall vividly from the summer, in July 2017, the federal court decision in the Access Copyright v. York case came down. I think it would be fair to say that it was a great disappointment for supporters of an educative, fair dealing based approach to, I see a typo in my backgrounder. It says an educative, fair dealing based approach to education. Obviously that means fair dealing based approach to copyright. With the judge ruling that York's fair dealing guidelines were not, in fact, fair, and the Copyright Board certified tariffs should be considered mandatory. The immediate direct impact of this decision is limited since it only applies to York, and furthermore, York is now taking the case to the Federal Court of Appeal. And this court, the Federal Court of Appeal's ruling, in turn, will almost certainly, because of the issues at stake, will almost certainly be appealed to the Supreme Court. Indirectly, however, the decision may contribute to legal chill and uncertainty, and Access Copyright and other parties are already trying to leverage the ruling to their advantage, as in their submissions on the Copyright Board consultations. And because those submissions have been made available online, per my previous bullet, you don't have to take my word for it. You can read their submissions online. At least one publisher is also known to have directly contacted academic staff at numerous Canadian universities and colleges, attempting to use the decision to sell course pack licenses. But there are few indications at this time of widespread changes to copyright policies in Canadian higher education. Looking ahead, copyright scholars who have reviewed the federal court ruling in depth believe that it is flawed and will ultimately be reversed through the forthcoming appeals. And I've included a link by way of example there to Professor Ariel Katz's very detailed, in-depth analysis of the court ruling. So those are the 3 points that we particularly wanted to highlight. Standard disclaimer there, what we've presented is not to be considered legal advice. It's presented exclusively for summative informational purposes for registrants in today's webinar, and it should not be construed either as representing an official position statement by CAUL-CBUA. And we're just having a little technical issue with sharing this backgrounder document with you.
I shared it, but it's it keeps telling me check your shared contents to find it, so I don't know why it's not wanting to link.
Okay, I'll have
in the chat. So it's somewhere in the meeting. I just don't know where. Sorry.
It's just possible. Oh, we've heard one person saying they were able to download it okay, so hopefully you should be able to receive it. But anybody who didn't receive any documents, just make sure we find out at some point during the proceedings and we can share it directly with you via email. And that's it from me at the moment. Thank you, and thanks for the folks who are checking in to say that they did get the backgrounder. That's the update backgrounder. That's helpful. And I think without further ado, I will turn it over back to Corinne, who has a scenario for you.
Great. Well, it's Denise here jumping in, just to say that now that Simon has brought us up to date with the most recent developments, we want you to think about how we put this into action at our public service desks. So Corinne and I are just going to present 2 little mini scenarios. Corinne is going to play the part of the professor, and I, Denise, going to be the staff person. And then we're going to have a little chat about it, and we've got some little prompting questions. And of course, we want this to be in light of the recent changes and the update that you just heard. So
before we get going, I just wanted to check with everyone. I just added the document we're working from as an attachment. Can anyone see that? Did it show up as a pop-up? Because I saw Simon's come up a few times, but I wasn't sure if you could see mine. Okay. Great. Same thing applies, though, of course, if we could send it out later if anyone can't get it. So. All right, looks good. Sorry, Denise, I cut you off a little bit there because of the slight time delay.
Not a problem. Important for folks to get the information about downloading these scenarios. Great. So without further ado, I'll have Corinne start off as Professor X at one of our CAUL University help desks.
Great. I should mention there's no affiliation with the X-Men franchise. Okay, so I'm basically a professor coming up to the desk, so I'll get going with our little role play scenario. Excuse me, I need to put this chapter up on my course site, but it's 12% of the book. What do I do?
Oh, you're referring to fair dealing guidelines? There really are guidelines, not rules. They're just a starting point for copyright interpretation. I'm happy to talk to you about it.
Oh, okay. That would be really helpful. Thank you. And if you don't mind, what's all this about York University? People are saying that copying is illegal now, fair dealing's out the window. What are my students supposed to do? What am I supposed to do?
Okay, well, it's important to know that the York case is being appealed. The university guidelines and practices around copyright still remain in place, and fair dealing is still your right.
Oh, okay. Well, that's good to know, at least. But what do I do about this reading?
All right, so that's the beginning of an interaction. That was Professor X, and now we're switching to Professor Y, who's probably just down the desk speaking to another staff person.
All right, so here comes Professor Y. Excuse me, I need to put this chapter up on my course site, but it's 12% of the book, so I guess that's against the rules?
When you say rules, you're referring to the fair dealing guidelines. They really are just guidelines. They're not rules. They're just a starting point for copyright interpretation. I'm happy to talk about it with you.
Okay, but what's all this about York? People are saying copying's illegal now, fair dealing's out the window. Are those guidelines even relevant anymore?
Well, it's important to know that the York case is being appealed. The university's guidelines and practices around copyright remain in place, and fair dealing is still your right.
Okay, but what do I do about this reading?
Okay, so end of scenarios, and now we want this to be a bit of an opportunity for us to share amongst ourselves. So there's some questions that we'll put up in the chat as well if you haven't been able to receive them. And what we want to know is, would your response to Professor X be exactly the same as your response to Professor Y, continuing with this scenario? And just kind of why or why not? And again, if someone can, come over the mic, or if you want to just use the chat box, please do so.
So I'll just jump in here while we're waiting to see if anyone wants to respond. The thing that we really want people to notice, of course, is that a discussion might not even be that different, but that the tone can be different and affect how you might respond to a copyright question, because it is a very charged issue in libraries, right? So, of course, tone, people's emotional attachment to the issue, people's fears and concerns, right? Okay, so a question from Victoria. I would be happy to address this one, if that's all right with everyone. Since I am manager of access services, obviously frontline service and customer service is something that I have to concern myself with, and that our staff have to concern themselves with. And the thing that I would like to point out there is that when it comes...
we should read out the question for those who are just on phone. Yeah.
I will, absolutely. Sorry. The question, thank you. The question says, with respect, these scenarios and questions seem to be more to do with customer service than the copyright update itself, and asking how it's relevant to the theme of the workshop to have these to frontline scenarios? And I think that's a fair question, but the point I would like to make there is that when we're dealing with frontline service in a library, it's really not simply transactional, as we all know, right? It's not just checking in and out of materials. It's not just the upload or download of information from one party to another. We are really, as the theme of the workshop here is, actually we're not on our own, right? We are kind of all in it together, whether it's librarians whose responsibilities specifically pertain to copyright, or whether it's frontline staff who need to address copyright in terms of reserves or document delivery, or even helping students use the photocopier. It's really an issue that has its tentacles in all parts of library work because of the nature of the work that we do. So if we think of frontline work as transactional and not educational, then we lose out on the opportunity to help all of the stakeholders in our libraries to have a little more comfort with the issue and feel a little more confident when approaching their own copyright issues with their research and their classes, etc. Did you want to add anything there, Denise?
Oh no, I think that sort of covers it, and that there's always an information that we need to know what's going on, but there's always that educational component as well.
Yeah, absolutely. And librarians and administrators who deal with some of the higher level copyright issues really need to rely on staff in frontline to know how to triage things, and they can't even do that without a baseline of knowledge and understanding of copyright issues and at least a cursory understanding of where issues are moving, like with the update coming up and the York case being appealed, etc.
And I am genuinely curious. I'm just wondering, is this kind of scenario something that people have seen at their desk in terms of the different tone or different questions?
So yeah, I'm curious, do you know Professor X and Professor Y? And I'll post a couple more questions. We had a little list of questions, and I'll put a couple more of those up in case they are helpful to people. So the questions that I'm posting in chat now are, what else is going on in the interactions besides potentially copying 12% of the book? That's the kind of the premise or the pretense of the conversation, but there's obviously a lot of stuff that creeps in there, a lot of other copyright issues and concerns and unease, right? And what would be the consequences of providing different answers or the same answer to these professors? Does their tone really warrant or demand different answers, or is a stock answer really what we want to go with, right? I could see some advantages and disadvantages there. And I hope everyone caught the pun on Professor Y, because Professor Y is really very interested in Y.
And I think too, this is where it's really good to tap into what resources are available to us when we're speaking with different professors, because I know this is a case where that fair dealing FAQ is really super helpful, especially if you're feeling challenged and you want to distance give the information and help in the educational process, but not feel on the line. Like that FAQ really helps with that process.
Mm-hmm. And it really, I've found that I've had to reinforce with faculty members more than once that it really is, again, going back to the dialogue itself, coming back to it really is a set of guidelines. It really is a starting place. And where universities tend to be bound by very concrete and thorough policies, that in and of itself might be something that is challenging for faculty and staff members to get their heads around, because it's a slightly different kind of document than they might be used to dealing with in, say, Senate, for instance, right?
Corinne and Denise, there was a question in the chat box about, so what would you guys answer in this situation?
Oh yeah, sorry, I saw that and I was kind of half answering it in what I just said. Thank you for pointing that out, though. I should have probably said that that's what I was doing. The end of those dialogues, they both end with, okay, what do I do about this reading? And that comes back again to, let's start with the guidelines, but the guidelines are not the end point, right? But of course, when you're dealing with professors who have possibly two different sets of vested interests in copyright, right? If you have Professor X might not be tenured, seems a little less confident or secure in their position. They might be working a term in the university, so they're really trying to get their footing and make sure that they cross their I's and dot their T's, right? Whereas Professor Y might be a faculty member who's a little bit more confident or was more comfortable possibly with how copyright was in years previous, and there have been a lot of changes in recent years that might be frustrating for that professor when they're if they've worked in the academy for a number of years, right? So for me, I think that my responses would probably be similar with both, but with slightly different treatment, bringing them back around to the guidelines, but emphasizing different parts of the guidelines are different parts of how the guidelines function and why they exist. Yeah, really good point from Tanya that they want a concrete answer, and then you kind of have to play. Socratic method with them a little bit, right? That the concrete answer is something they have to work toward themselves, and all we can do is nudge them one way or another depending on what information they provide us with. Well, consider this factor, consider this factor. This tends to be considered less fair, more fair, etc., and help them along their way toward what an appropriate fair answer is to whether the copying they're doing is fair. I'm talking a lot, Denise. Help.
So, I was going to say too, I mean, the answer depends a lot on the conversation and
yes.
the tone, which is precisely why we chose these two scenarios, because much of it depends not all on the staff and what information they have, but on the other side of the counter and what's coming there, and I think again that's where you want to key into what resources you have available. So even if after you've discussed the FAQ and sort of given them ask them questions along what is fair dealing, if you're still feeling okay, the person doesn't really feel happy, I mean this is a great place to then refer them to the copyright officer and say
the clear answer might be a clear referral to someone and a business card and mentioning that title, that this person is the copyright officer, and to kind of reassure them that it's not that we're setting you out to sea on your own, it's that it's a matter of guidance, and we can provide you with some good guidance.
And I'd like to turn the question back on our audience, our participants. So what are the answers for you? Like, are you sort of thinking what we're seeing here is sort of what you would do, or do you have a completely different take on it?
Oh, that's a really good question in the chat box right now. Are you saying that if a professor asked this question, you would refer them to the Copyright Office? To refer back to Denise's point about tone and about how the conversation continues to proceed, I could see either of these dialogues going either way. You might be able to stand there and work with them for a couple minutes and go over a few factors in the copyright guidelines and see them feel quite sure, oh yeah, my students really do need this. It's not an excessive amount of copying. In the context of my class, using this resource makes sense, etc. And see that they have had that light bulb moment about what really seems fair in the context of their research or their classroom. And in that case, you may be able to consider the matter fairly settled. I mean, document delivery and reserves, for instance, have to deal with these little these gray areas every day, right? But if you're still getting some pushback or you're detecting a lot of unease, or the question actually proves to be more complicated than it seems at first, then that might be the time to pass them on to the Copyright Office. But you've done it with, make sure you're doing it with, you've had a good dialogue, you're providing them with as much information as you can, so you're not giving off, you're not passing them off, you're not passing the buck, you're passing them on or referring them on when it's appropriate after you've done the best you can. Yeah, Tanya raises another good point here. It could be an opportunity to make them aware of the Copyright Officer. In my experience, a lot of faculty and staff do not know that a Copyright Officer is a position that exists in our university library. And especially because in a lot of, I think in a lot of universities like ours, it tends to be someone who wears that hat as well as another hat, for instance, university librarian or another type of librarian.
Excellent. Should we move on and listen to Josh's scenario next? If anyone has any questions, we'll still have some time at the end of the session.
Sounds good.
That sounds great. Thanks, everyone.
So Josh, are you there?
I'm here, I hope. Can you hear me?
Yeah, I can hear you really well.
Thanks, Denise and Corinne. That's great. I'm Josh Dickinson. I'm from the University of New Brunswick. I'm the Copyright Officer here. The scenario that I picked to put together hopefully is being passed around right now. I can't send this around. If you're able to pass that around for me, that'd be great. Is one about, it's not necessarily classroom or educational per se within the context of our e-reserves or our CMS system, but something that sort of comes to the office here on a frequent basis, that instructors or researchers would like to share some of their information outside of the confines of our systems here that protect us and help with our fair dealing analysis. And I think as copyright either officers or people with responsibility with copyright, that's part of our role, is to interpret fair dealing beyond what's going on just in the institution, and people can use copyright or use fair dealing in their own research and scholarship. So the following scenario looks at the importance of context and risk, along with the fair dealing purposes and factors that are in the Act. And this will help users decide upon the limits of sharing before they decide if permissions must be requested. But in the end, what is most important in any discussion I have, whether it's either institutionally or outside in their own personal dealings with other people's work, is that this decision is ultimately yours in the end, and that we can help with guidance as opposed to giving you black and white direction at that point. So how this particular scenario came about was an instructor emailed Copyright at UNB and said that they had an idea for a project and they'd like to incorporate popular cultural images and academic analysis in an openly accessible blog. The instructor researcher wanted to open this up to fellow colleagues across Canada and possibly the US, and wanted to know if everyone had to get permissions before they could make these entries public, and should the individual who contacted me be responsible for this, or should each submitter to their blog go after permissions? And I think what spurred this conversation on was that this particular instructor and I had met and gone over a book agreement with a publisher that she was going to sign and start working on a book, and the publisher, as is customary, was very restrictive in their interpretation of any third-party materials that were going to be in part of her book. So that was the interpretation that she'd come away with providing other people's material in a public forum. The other example that she had was our Universities Canada-based guidelines that we've adapted to our UNB procedures, and they're pretty black and white as well. 10% a chapter, and all of that seemed pretty restrictive to her. The things that she wanted weren't necessarily chapters or articles, so it opened up a better discussion for us to look at fair dealing. So the next step I try to do in any of those types of open questions is get some details back. So I emailed back and I told her, it sounds like a great project. Can you tell me more about the intended audience and the long-term use of the works that will be created by the blog? And these are good details to get on paper. If you can encourage a response with a bit of detail, the answer that you provide or the guidance you provide will be much easier. So the instructor came back, and I'll tell you the instructor didn't respond to my request to cut and paste and copy the entire correspondence, so this is edited. The instructor came back and said that she wasn't very sure where it would end up, but they wanted a space where colleagues that she'd met in a conference, I guess, could collaborate on the interesting ties between what we see on TV or movies and its roots in science. The ultimate goal will be able to use this as a teaching resource, but not limited to each contributor's respective classes, but we hope to share this resource with other researchers and discipline enthusiasts. So it gave some detail, where do you ultimately want to see this content go? How widely is it going to be distributed? And you can sort of get some of the purposes and the character and the nature of what the sharing is going to be, some of the questions that you need from the act itself, rather than the context and the risk of what you're doing with the content. So my response back was, I'm happy to help out. We can discuss the significant parts of the act, any relative information that looks at past cases and this types of sharing, which is more technical stuff and difficult for most people to sift through this. So I can help in that part, pointing to the information that's out there. But in the end, again, the copies that you make of another person's work are going to be your decision. So at this point, we've sort of gotten down the information of what the end project's going to look like and made it clear where I can help and that it's guidance. So I find at this point, if you can meet with somebody or talk on the phone with them, it not only helps sort of shape the discussion, but it makes sure you don't put anything down on black and white that you may regret later on. So it's, you're still dealing with legal advice and all of the information that you're providing is nice to caveat with this is, I'm not a lawyer, and you shouldn't take this as the absolute way to go. I'm not giving you permission to use someone else's work. We're discussing it. So a conversation usually works best with me. So with this case, our previous conversations about fair dealing were very helpful. She had a perspective of what the publishers needed in terms of their liability, why no fair dealing really worked in that avenue. Educational institutions, why we are a bit risk adverse as well, and the places that we can push fair dealing into a safer space, such as our CMSs or our course reserves. But then now a place where creators and users will find themselves sharing material in their materials. So of course, as usual, once we start talking about fair dealing, York comes up and the risk that they took in doing the same thing. And like Corinne had discussed earlier, and Denise, that York is being appealed, but it shows us some interesting aspects of the act that we should all consider. It might not be made into sound jurisprudence yet, but we should look at what that judge said and follow some of those industry practices that they pointed to. In the end, we narrowed down 3 different places where the images, how she could use the images, depending on who submitted what. In the case of showing it in the class, we were able to go to the exceptions. Films, clips from films could be used without asking for permission, as long as it was within the classroom setting. If you wanted to take screenshots of the film, put them on the D2L within our institutional policies, that's easy enough to look up. Behind password protection, you can share this clip with students. It's going to fit our fair dealing guidelines. But then the third scenario that she wanted to do was to make this blog available, and that was her ultimate goal, and what she wanted in the end to see happen with this research. The final tool that I find is most helpful when we're working outside the institutional sort of protective blanket is thinking about licensing content. So even within the institution, if we're going to open something up, say on the library's website, or ITS has a blog that they put together, it's still an open resource. And what I've found to be most helpful is to introduce people to the Creative Commons license. That way, I can talk until I'm blue in the face about what fair dealing means and the different contexts of what the risk is, putting it out from a university, putting it out from an individual. There's not much gain in Mickey Mouse suing me as an individual, but if I put it out as the University of New Brunswick, I'm sure we've all seen those trolling emails saying, this has been up since 1994 and here's what you owe us. So there's some risk involved there, but what keeps the institution or individuals safest and encourages everyone to think about what they're doing is to look through that Creative Commons license. There's a very straightforward tool on there, and it shows you what you do intend on seeing this document live in the future. How you want other people to use it, I guess, is the difficult part for a lot of the copyright clearance people. Is there's a document online, I don't know who created it, what they want done with it, or how we can share it. So by asking people to pick out a Creative Commons license, it expands that conversation enough to help people understand what they are doing by using others' materials and how they'd like to see others use their materials. Once they've picked out a license and slapped it on there, it's there forever. So that's important to make sure people understand that. But the Creative Commons wiki and their website is a very good tool for that, and I can't stress it enough within your own institution or having people use it in their own personal work as well. It's been invaluable here for the type of fair dealing and copyrighted use that doesn't quite fit into our guidelines, whether they're University Canada or Community Colleges Canada, or ones that have been created by the institution itself. So I highly recommend people going into that site and using it whenever possible.
Awesome. Thanks, Josh. Do we have any questions?
And if anybody has other sort of fair dealing or copyright tools that are outside of our institutional policies, right, I'd be glad to hear about them and help expand our repertoire.
Okay, well, if you think of any questions, we'll have some time at the end. Is there anything else you wanted to add, Josh, or are we good to move on to talk about film on campus with Simon?
That's it. Thanks.
Okay, so are we ready for a third scenario about films on campus? Okay, Simon, if you're ready.
Hello again, it's Simon Lloyd at UPEI. Hopefully everybody can hear me all right. So the scenario we had was a little while ago. The university librarian and I received an email from Student Affairs here at UPEI. And Student Affairs had received an email from Audio Cine, and some of you may be familiar with Audio Cine as one of the companies that sells licensing on films, especially Hollywood feature films. Now, what Student Affairs had done, they offer an ongoing series of programming called Campus Life Movie Nights. And they, back in November, I believe this was, they had shared a web announcement for an upcoming Campus Life movie night of it's a sports movie. Some of you may have seen it, called Rudy. And there was nothing in this web announcement that really mentioned any educational purpose, like a panel discussion or what have you. And that was unfortunate. I'm not criticizing Student Affairs, but that was unfortunate because, in fact, as part of this series of Campus Life Movie Nights, there actually usually is what could be broadly construed as an educational purpose. There'll often be a facilitated discussion or panel discussion, questions and comments about the movie afterwards, and so on. But in this particular case, there was no mention of that in the announcement. And also, due to a blip, I think, instead of being posted on the campus-facing web announcements, it was posted on the public-facing public events calendar. A couple of interesting things about that. Most notably, when Audio Cine emailed UPEI Student Affairs, they included the link to this announcement. So we could construe from that Audio Cine is watching websites for things like movie performances. The Audio Cine email was not in any way discourteous, but it did say that they viewed this was not an educational purpose for viewing, and that therefore a license should have been obtained in this case. This hinges on a section of the Act. We've talked quite a lot, and rightly so, I think, about fair dealing today, but it is important for us to remember, I think, that there are other changes to the Act that came through in 2012, and a very significant change was to Section 29.5 of the Act, which talks about performances. And it specifically says that it is not an infringement to show a film on campus for educational purposes, so long as it's targeted primarily at an audience of students at that institution. And as I say, in the normal course of things, this Campus Life Movie Nights showing would probably have been covered by Section 29.5 because it was clearly targeted at students, and normally when they present a film, there's clearly an educational purpose. So in this case, though, because that wasn't done, the university librarian and I discussed this. We also had some discussion with our colleagues at Student Affairs, and we decided that it would be appropriate in this case to purchase a one-time transactional license. And of course, Audio Cine is not going to turn down their money, so they were more than prepared to accept that payment retroactively. They also, of course, Audio Cine is a business, so they also, in their business-like way, highlighted in their initial email to Student Affairs that they were more than happy to sell a blanket license for the campus at a considerably higher price to cover all future screenings. Now, what we emphasized in our response to Audio Cine, the library, in the interest of being supportive and collegial, did offer to sort of chime in on Student Affairs' behalf in the correspondence with Audio Cine. We didn't just push our way in, we told Student Affairs what we were doing, and they were more than fine with us to follow up with Audio Cine, keeping Student Affairs in the loop, of course. We arranged for the transactional license, and we then explained to Audio Cine that we agreed in this specific case. I just saw a question pop up about precedent. We were very careful in our email, and all our communication with Audio Cine was via email, so there's a bit of a documentary trail there. We explained that this particular showing of this particular screening, because it did not properly highlight the educational purpose and did not clearly explain that it was targeted at students primarily, we would be paying for the one-time transactional license in this case. We were careful to explain, though, that we didn't view that as setting a precedent. Now, I know there's nothing more electrifying than having emails read through the computer to you, but I do feel that we had a very cordial response again from Audio Cine, and of course they were obviously pleased that we were purchasing a transactional license in this case, but they are continuing to argue for the precedent here, and I do think this is worth quoting, and this will also be quoted in the background document that's been shared with you. So I'm quoting from Audio Cine's email here. From our point of view, the only cinematographic screenings that are exempted by the Copyright Act are those that fall under the, quote, educational exception, unquote, clause, i.e. curriculum-related classroom presentations. All other movie activities, such as movie nights, film festivals, fundraisers, and screenings organized by student groups, are occurring outside of class time hours, are by default, quote, leisure in nature, close quote, and require licensing. Campus life movie nights occurring in a student center are clearly leisure in nature. So if you go back and parse through the Act and or any jurisprudence thereon, there is nothing that we could find, and again, if anybody has heard of anything, please do feel free to share, but there is nothing that we could find that supports that leisure in nature interpretation that Audio Cine is relying so much on. So we just very politely replied to them, acknowledging that we had received their interpretation, and left it at that, and we haven't had any further communication with them in the month or so since. So I think there's a few points we've also been in touch with Student Affairs and said, going forward, you know, please explain, because it's important to emphasize that we're not looking to force open any loopholes here or anything like that. Like, Student Affairs has quite genuinely of its own accord been including an educational component with these screenings. They just forgot to mention it in this one particular posting back in November. So we've explained to them going forward that you certainly should emphasize that this is targeted at UPEI students primarily and highlight the educational component of the screening, i.e. the panel discussion and so on. And that's where things stand at the moment. Now, of course, this is copyright, and perhaps even as I speak, the Audio Cine gunships are in the air, but we're fairly comfortable with things as they stand. I think the sort of key highlights that I would mention in this case is, you know, coming back to the theme of this workshop, we're not on our own. We really feel we had a good discussion with Student Affairs. They contacted us themselves as their own initiative. We had a really good discussion with them. They understood that we were just working to be helpful, to help them do the work that they would be doing anyway. We're not looking to be their lawyers, and we're not looking to be police officers either. We're just looking to work with them so that they can do what they need to do. Obviously, the need to communicate respectfully and carefully with a rights holder or a rights holder representative like Audio Cine. So, you know, you're not creating precedents, you're not giving the game away, so to speak. Yeah, I think those were really the two main takeaways. I'm sorry, the third takeaway, of course, is to remember that fair dealing is very important and very valuable, but there are other very useful and valuable things that came into the Act in the course of the Copyright Act modernization process in 2012. So those are the few things I would highlight there. Definitely open to, I see time is marching on, sorry I went a little long, but definitely open to questions and to comments. Thank you. I see a question here from Susan Kleil. If the movie showing was put on by Student Affairs, doesn't it logically follow that the intention was for students to see the movie? Yes, I would agree with that. If I had to rewrite the backgrounder of this, I probably should have included the announcement on the website that we could have gone another route with this, I guess I would say. We could really have dug in a little bit and pushed back more firmly with audio cine than we did. We could have said, well, look, clearly if you look at this in context, this Campus Life movie nights, it's offered by Student Affairs. Clearly, obviously, it's targeted at students on campus. In this particular case, because of that announcement, and also because the film in question was, a Hollywood feature film, we decided that it was maybe just better to concede the point in this specific case. Just seeing a couple of other questions here. Heather has asked, if you don't advertise externally, are you okay? Again, that would be a matter of interpretation. Our advice to Student Affairs was that in any advertising that you do of something like a film screening, do please emphasize that, if it's targeted primarily at students, primarily at the campus community, if you like, then, or no, I should be more specific than that. If it's targeted primarily at students, then make sure that any advertising you do references that. Tanya Harrison has just shared, we have an audio cine PPR a public performance right license at 75 cents per FTE. We have many campus screenings that are educational in nature, but many more that are not, and no resources to keep up with these sorts of instances. Yes, it's, as with all of these scenarios, I think, we're not looking to lay out, a one true path here or anything like that. It's always going to be subject to a degree of ambiguity and uncertainty and issues of interpretation. For me, myself, Donald Moses, the university and librarian, and myself, I think for us, our read in this case is that we should not be too narrow in interpreting that notion of educational. That is not to say that there aren't things that happen in terms of movie screening that are not educational. So we voluntarily ourselves, back in, just to give you an example from Frosh Week, last semester, we had a screening of the X-Men spin-off movie Logan, and that was not billed as anything other than it's not a seminar night about Canadian superheroes or anything. It was just purely a fun, have some popcorn and watch a movie thing. And we paid for one-shot transactional license for that up front. But on the other side of the coin, earlier this semester, we offered screenings of several NFB documentaries and invited the campus community to those. And that is clearly educational, just because it's not being offered in a classroom setting during classroom hours. It's, to our eyes, that's clearly educational. And as I say, as to the Student Affairs screening, that Campus Life movie nights, yes, they're showing a lot of Hollywood fun stuff, but they're having actual substantive discussions about it. So our read was that was educational. Tanya just offered a quick clarification here. I should clarify, we have kids programs that are commercial childcare, so our license covers this as well. Yeah, again, it's... and one of the reasons I backtracked a little bit when I used a broad term like campus community a couple of minutes ago is there's all kinds of things going on campus. Within our campus framework, they have, we have units that are operating on a for-profit basis. Our food service provider, and this is a purely hypothetical for example, but if our food services provider Chartwell's wanted to have a movie and dinner night or something like that, there's all kinds of gastro films these days, we would look at licensing for that. It would be a real stretch to my mind to argue for that as a educational enterprise. So yeah, that sort of gives an outline. And yeah, Denise makes a good point here. Thanks, Denise. This scenario at UPEI also points to an ongoing conversation with copyright holders. The sky did not fall, yet, so to speak. And that's, yeah, thanks, Denise. That's when I pitched this scenario to the group, I said, that's the big thing, Audio Cine, their initial email to Student Affairs was brusque, but it wasn't, threatening or anything like that. And Student Affairs remembered that they weren't on their own and spoke with us about it. And, as I say, all our communication with Audio SUNY to date has been very respectful and matter of fact, and they haven't conceded their interpretation and we haven't conceded ours, but except for the one transactional case.
Awesome. Thank you, Simon. So we have
Thank you.
few minutes left. If anyone has any other questions that might have popped up throughout the other scenarios, or if there's anything else that the presenters wanted to say but didn't get to say.
Yeah, this is Corinne. I'd like to mention something just that I wish I'd mentioned earlier, if that's all right.
Mm-hmm.
I was recently I went to OLA this year, and there was a fabulous session that I wish everyone who's in this webinar could have been at this session. It was about copyright chill and the kind of collateral damage that it creates in terms of education. And it was quite poignant because the presenter, whose name I forget, and I apologize for that, she gave the situation of, or provided the situation in a kind of another scenario that would go well with this webinar, of an educator who relies only on the fair dealing guidelines of their institution as a kind of a word problem or a logic problem, that's the only resource they really have access to, and because of that they interpret it strictly. The resource they want might be a smidge outside of the parameters of those guidelines, so they settle for another resource that is not actually ideal for their classroom. They're settling for what's not actually ideal for their students or what they're doing in terms of education. And her point was just that the onus is on us as people who work with copyright every day to combat this kind of specter of the right answer, right? The right answer is the one that you arrive at by this careful, thoughtful interpretation that takes into account your guidelines, takes into account the actual legal discussion that comes out of the Supreme Court, and that we really can't do it only by self-referring to this one set of instructions or guidelines that we have easy access to. But as Denise was prompting this question earlier, what other resources do we have access to? We have the Copyright Act itself. We have case law. We have access to our consortial partners. We have access to our copyright officers, and that kind of nuanced interpretation doesn't just come down to right answer, wrong answer, and that's something that I understand the seduction of it, but we want to really try to be a little more careful with, I think. I'm done.
Awesome. Thanks, Corinne, and thanks, Jeannie, for the link. Do we have any other questions? I think that might be a wrap. And if you think of any other questions or anything that you want to pick our brains about, I think we're all pretty open to discussing any of this.
Just a reminder that the session recording will be available on the CAUL website. I'll send out an announcement when it's up. Well, I guess I did the session. I'm just going to stop the recording now.